panelists. And so panelists, if you all could turn your camera on whenever I introduce you so people can see who you are, and then turn your camera off once I jump to the next panelist. So our first panelist is Jonathan Trunnell. Jonathan is a managing attorney at Disability Rights Louisiana. He graduated from the University of California, Hastings Law School in 2011. He is currently focused primarily on special education, criminal justice, and Medicaid issues. So welcome, Jonathan, and thank you so much for joining us today. Our next panelist is Cindy Obier. So Cindy graduated with a degree in architecture in 1981 from Louisiana State University. She is a licensed architect and has worked in the field of architecture for 40 years. She has worked for the Louisiana State Fire Marshal's office for the past 24 years. She has conducted seminars for reviewers and inspectors at the Fire Marshal's office, as well as for architects, engineers, and the general public pertaining to compliance with Louisiana State promulgated accessibility codes. Thank you, Cindy, also for joining us today. Finally, but certainly not least, we have Andy Bizer. Andy is the founding partner at Bizer and DeReus and is admitted to practice law in Louisiana and New York. He graduated from Tulane University in 1997, and he graduated from Brooklyn Law School in 2003. Andy has been advocating for the rights of individuals with disabilities since 2010, with his focus areas on equality for individuals who use wheelchairs, as well as those individuals who are deaf and hard of hearing. So thank you all for joining us today. We're going to go ahead and get started with the presentations, and Mr. Trunnell is first. So you can go ahead and get started.
All right. Well, with the privilege of going first, I guess what makes the most sense to do is to start by pulling back out and looking at what disability rights are high up, and then kind of zooming down into what is specifically meant by accessibility and how that applies during trying times like a pandemic. So having a right is a concept in the law which is very different from something like having an entitlement or having some kind of charitable nice thing that's done for you. Having a right means that you hold on to that right even when there are extenuating circumstances, or even when it might be inconvenient for others for you to hold a right. And the disability rights movement is about attaching people with disabilities to civic life through rights, not privileges, not entitlements, not things that can be lightly taken away. And so when we talk about the disability rights movement, what we're really talking about are how we tether people with disabilities into civic life and how we make promises that are intended to be unbreakable. And things in the ADA, you have, of course, your architectural requirements, and those are very straightforward. For instance, during the pandemic, I recently went to go get a COVID test from a testing site that was operated by the city of New Orleans. They have a series of partnerships with private organizations where the city of New Orleans will go out into other community centers and set up medical testing zones in those community centers. Now, I happened to get around in a wheelchair, and the testing center that I went to didn't have a wheelchair accessible entrance. And so that is one way of thinking about what is accessibility. And in general, if I ever wanted to go back to that community center, I would have a good cause of action that they would need to make some architectural changes if they were going to continue to be a place of public accommodation. But because we were dealing with the city and also medical testing, there were a lot of other wrinkles. It ended up not being as bad of a situation as it might have been, in part because the ADA also thinks in terms of your access to programs and other benefits of the government of which you are a part. And in this case, what I said was, hey, I'm a person in a wheelchair, I can't get into this building. And based on their facial expressions, there were clearly a few moments where the person hadn't really considered the possibility that a person with a wheelchair might be coming to this facility on this day. And what they ended up doing was allowing me to participate in the program of receiving a COVID test from the city of New Orleans by having the doctor leave the building and come out to me. Now, under these circumstances, where it's a pretty straightforward thing and they're just swabbing the inside of your nose, having it done on the sidewalk was less of an inconvenience and may even have been safer in some ways than going inside. But you could also easily imagine other medical procedures where having only access to the doctor on the sidewalk would be decidedly less than and unacceptable. And really what this ties into, and what I'm hoping to get a chance to talk with all of you about today, are the ways that your rights continue to apply, even inside of a pandemic. That having a right is an unbreakable promise, and disability rights are not privileges or entitlements where you can, in the event of an emergency, sort of cast them aside. These have to be the principles that shape how we respond to an emergency, how we set up new government services, and how we address challenges we've never faced before. And the best things about our democracy, and the things that I think are, the worthiest part of our political tradition, is thinking in terms of these individual rights and trying to structure government actions and reactions to new things around individual rights. So that's sort of my quick introduction. And this is going to be playing out across the state, not even just with testing, but with things like housing, things like access to the courts, access to all of the programs government runs, and even in extremis, access to medical services and the right not to be discriminated against in the event of medical rationing. So this is an extremely wide topic, but I am glad that I get to sort of speak first and set the tone by talking about what I think disability rights are and what accessibility means during a pandemic.
All right, thanks, Jonathan. I guess I'll go next. I'll just jump in there. I'd like to follow up on what Jonathan said. I really liked how he was talking about how these are rights and these aren't like, something we're just giving to you because we're nice, or you only get in good times. The ADA says that there is an affirmative duty to accommodate. So if you have a disability, and for instance, with Jonathan's COVID test example, coming to the curb is a great accommodation in my estimation. so you don't have to go inside and have to mess with anybody. And you don't have to use magic words. You don't have to have a lawyer draft a special letter for you. If you make a reasonable accommodation request of at least of a governmental entity, they have a duty to engage in a dialogue with you to try to work out some type of an accommodation. So a good example is we recently filed a lawsuit against oh, by the way, a little bit more about myself, just to remind you if you don't remember from the intro. I'm a private attorney. I don't get federal funds. I don't get any grants or anything like that. Folks have discrimination based on their disability, and they contact me. And I was recently contacted by the nation's oldest elected official, Mr. Harry Silver, City Council member of Alexandria, and he has a heart condition. And he's also just an old guy, right? And so he wanted to attend his city council meetings remotely, just like we're having this meeting remotely, and they denied his request. And you know, it seems ridiculous to you and I, if you're on this meeting that we're watching now, this virtual, what I don't even know what this is called, whatever, panel, excuse me. We're doing this virtually. Why can't they do the city council meetings virtually? He made the reasonable accommodation request. They denied the request. They chose not to work with him in any way. We had to file a lawsuit in federal court. And then we filed a motion for preliminary injunction, and we won. And our argument was his heart condition caused him to be a person with a disability. And his heart condition previously did not stop him from going to the city council meetings, but the presence of COVID made the manifestation of his disability just a bit different and needed a different accommodation. And they chose not to engage in any type of dialogue, so we sued them, and we were successful. And now he's attended 2 city council meetings remotely. So I bring that story up because, as Jonathan said, you know, this is not something that, these are federal laws, right? And the federal laws have to keep local municipalities in check from discriminating against folks with disabilities. And there was at the time a state law that said city council members had to be there in person. But federal law trumps state law. And so, you know, the laws were built without any type of, well, you know, you got to accommodate this deaf guy, but there's a pandemic going on and we can't do it, right? If Congress had that intention, they could have drafted the ADA in that particular way. We've got 2 other COVID-related lawsuits that we filed. And in fact, the other 2 are against the state of Louisiana. And I was tickled to be invited to the governor's panel on ADA accessibility because we sue the state of Louisiana all the time. The Department of Health put out a really bad notice on their website about rationing care based on disability. There was a paper published in Washington that had some guidance that was just clearly discriminatory. So we sued, and they were kind enough to take that down off of their website and then add a new directive to talk about how you can make, if say ventilators need to be rationed, right? You can't say to someone, because you're paralyzed, your life is worth less than someone who is not paralyzed, and therefore we will give the ventilator to that able-bodied person. Now, of course, if they have to look at you from a doctor's perspective, but they can't just immediately go, all right, well, we got a paralyzed guy and a not paralyzed guy, and they both have bad, symptoms of the coronavirus. So we're just going to give the ventilator to the guy whose legs work. It doesn't work like that. And so we made sure that they put out guidance to make that clear to the doctors and nurses. And then finally, our other lawsuit that we filed was on behalf of patients at the Eastern Louisiana mental health facility. And that's the main place where they put folks who are not competent to stand trial or found not guilty by reason of commonly known as insanity. And a lot of those folks have been asking for reasonable accommodation requests regarding COVID and being quarantined and social distancing and things of that nature. And we're working on that as well. So yeah, there's a lot going on in this world, especially during this pandemic, but the building blocks are in place, right? And the key is that just because there's a pandemic doesn't mean that we throw this stuff out the window. You just look at it through a different prism and see how one's disability manifests itself during this pandemic, and that public places of accommodation, they have to affirmatively accommodate your disability, and the onus is on them, and I think that's important to keep in mind. So thank you.
Thank you, Andy and Jonathan. Ms. Cindy, would you like to follow up on either of their comments?
Yes, I have the shortest time slot here, and I want to comment on what Mr. Andrews said about the time of COVID pandemic not being a time where people are particularly discriminated against. And as a person who works with the state fire marshal's office, what we are doing in order to make sure that there is no discrimination is to do business as usual, to make certain that people who are adjusting their plans, their tenant spaces for the reopening of businesses don't do so in a way that is discriminatory. Obviously, the occupant loads in tenant spaces, assembly spaces are lower now. Right this moment, we're at a 50-person cap and 6 foot away from all other groups or individuals in a tenant space. Well, that means that a lot of the restaurants are going to be eliminating maybe more than half of their seating, and we make certain that that doesn't mean that the seating areas allocated for people with disabilities are the first, second, or last to go. We make sure that there is an even distribution of seating for people. What we typically do has not changed very much. We review approximately 18,000 plans a year. We have 25 review architects. So that's approximately 720 plans per year per reviewer. That adds up to an awful lot of plans per day that each person reviews. Then we have inspectors that go out after the projects are constructed, and they make certain that the plans were constructed according to the way that they were reviewed. What happens right now is that we are doing, let's say, double the inspection work in some respects, because when businesses are reopening, they have to submit reopening plans to our office. If it's not a very simple thing, if it's an assembly space or some sort of gathering is planned, then they have to present us with an opening plan. If it's anything other than what the governor has mandated, And then the inspectors go out and look at what it is that they have proposed. We review everything from snowball stands to hospitals, and that keeps us especially busy. We're working from home right now, so it's very efficient in terms of review time. We are still answering questions for people who call in and have any kind of an issue with how it is that they can comply. But the main thing that we need to do is to do our business as usual and to continue to cite compliance with accessibility codes and to inspect for compliance with accessibility codes. We, at one point, and this may still be the case, we were the only state that not only reviewed for accessibility for every building in the state, but also we're charged with the authority to inspect every building for compliance with accessibility issues in the state. Typically, that is the Department of Justice task, and the state of Louisiana does take that on for other than the federal buildings. That doesn't mean that the Department of Justice doesn't come to Louisiana and address complaints. The Department of Justice also addresses any sort of issue that has to do with an existing building, because the Office of State Fire Marshal reviews new buildings, additions to buildings, renovations, and changes of occupancy type. If it's not one of those, then it won't come across our desk. If it was constructed prior to 1995, when we were given the authority to review and inspect, then it will not come across our desk. It will go directly to the Department of Justice. I can talk at some point about which codes we use to review. That's a sort of a dry subject, and I hope if anybody's interested in that, I can go through the different codes. At one point, we were reviewing for one code, and that was the ANSI A117.1, and then we were reviewing for two codes when the ADAG came along. Then we got to the point where we were reviewing for three codes when the IBC was promulgated, and chapters 11 primarily and part of chapter 10 addressed accessibility issues. And at one point we became the authority having jurisdiction over the review and enforcement for fair housing for apartments only. So when we got to the point where we were using 4 different codes to review and inspect for, and the architects, engineers, and moms and pops were trying to design using all 4 codes, we were given some assistance by the Advocacy Center, and they met with a legislative committee to lobby for giving us not only the authority to review for fair housing, but for causing the ADA ABA 2010 standards to apply to all residential units and not just public housing. So that's something that's very different in the state of Louisiana. So I think that's kind of a broad overview. And I'll see if there's any questions or if there's anything somebody wants to respond to.
I actually have a question for you, Ms. Cindy. So, what do you feel has been the biggest challenge in terms of accessibility and like reviewing these, like the business plans or plans for different establishments reopening? What's been the biggest challenge for you all in terms of ensuring compliance with ADA standards?
Typically, I would say that that is to make certain that there is adequate seating for people with disabilities. A lot of the, in assembly occupancies, a lot of the restaurants have moved towards outdoor seating. Some of them have erected tents. Well, there has to be an accessible route to get into the tent. There has to be seating. There has to be an accessible route to get to a toilet room. You have to be able to order from a menu the same way that anybody else would order. So primarily in places of assembly, that's been the biggest challenge, but the challenge has been more one of educating people what it is they have to do rather than any sort of pushback against that. I don't know of anyone who has either balked at or refused to comply. Typically, we just get questions. In fact, people are fairly proactive about asking questions as to how they can accommodate people with disabilities.
Thank you. So I know we had time slots for everyone to present, but if you all prefer like a question answer type style panel, we can do it that way. Or if y'all had presentations that you wanted to go through, we can also do it that way. So it's whatever y'all prefer. Jonathan, Andy, Miss Cindy, what would y'all prefer?
I could do questions if anyone has any.
Yeah, same.
Questions are always easier.
Awesome.
Yeah, I mean, we could talk about this stuff for a while, but maybe the audience could sort of push us in whatever direction they're interested.
Okay.
Kiara, this is Bambi. If there's anyone, any attendees that have questions, if you raise your hand, we can move you over to panelists, and that way you can ask the questions yourself. They can type it in chat, or if they're on YouTube, they can type it in the comments on YouTube. So there's multiple ways that questions can be asked.
Great. And while we're waiting on attendees to ask those questions, I do have a couple written down that can be posed to all of you. So because we are in uncharted territory with COVID, how are individuals with disabilities, as they approach accessibility issues, how are they to report these issues? Are they to go through the normal channels of reporting, or have there been other protocols put in place in order that their rights are preserved?
So this is, oh, I'm sorry. Cindy was raising her hand there.
We'll go. Well, whoever was first. I'm visually impaired, so these.
Oh, my apologies.
I'm not gonna see.
I have just a brief answer that I think touches on things, and then I'll hand it over to Cindy. There is no, there's no special, like Mr. Bizer was saying, there's no special language or magic word you have to use when you are requesting a reasonable accommodation. You just have to find somebody who works at a place or is the contact point, and you can get started. Now, that doesn't mean that you are sort of freed from the search of having to maybe find an ADA coordinator or get in touch with people as you move up a chain. But in general, I think people in general are trying to be responsive. And the way that you, I think, best help yourself is if you encounter a barrier to using a service or a place of accommodation, or you're unable to participate in an activity at a business, the thing to do is to bring it to somebody who works there's attention as soon as possible. And that should trigger a process of people trying to figure out how to accommodate you. That process is not always successful, but your chances of success improve the sooner it starts. If your problem is more architectural in nature, like for instance, I couldn't get into the building where the COVID test was taking place, it might behoove you to find out who runs the building and try to get in touch with people through that normal chain of command. But there isn't any sort of a special process or any sort of suspension of people's normal obligations to handle a request for a reasonable accommodation just because it's COVID now. So they shouldn't have to run you through any extra steps, and they can't defer their responsibility elsewhere by saying, no, that's not me, and just pointing away. And everyone should have all of their old obligations. And among those are responding to requests for reasonable accommodation.
Thank you so much for that. Does anyone else have anything as a follow-up to that comment?
Cindy has her hand raised. Go ahead, Cindy.
Now, can you hear me now? Okay. The Office of State Fire Marshal addresses complaints that are published on opensafely.la.gov. And that's all one word, OPENSAFELY at la.gov. .la.gov. That is a website that the governor's office has established, and you are permitted to type in whatever your complaint is, wherever the address is. And I think the first thing you're supposed to do is to approach the tenant manager first and tell them what it is that your complaint is, and see if they intend to address it. If they say that they will, then perhaps there isn't anything else that you need to do. If you go back and find that it hasn't been addressed, then maybe you'll want to put that in opensafely.la.gov, and an inspector from our office will go out and check on it. You have to keep in mind that this is for every state for every building in the state of Louisiana, and we will do our very best to get there as fast as possible. That's why we ask that you go ahead and speak to the owner, manager, whoever it is that runs the business first, and see if some kind of an arrangement can be made. But we will get out there and address your complaint.
Could you repeat the website? I'm going to put it in the chat box for everyone as well.
Yes, it is OPENSAFELY at back up, opensafely.la.gov.
And then my just contribution to this is I file lawsuits against owners of properties all the time who don't modify their facilities to make it accessible. We file suit under the ADA and also under the Louisiana Commission on Human Rights. And I'd say 99 out of 100 times whenever we file a lawsuit against a McDonald's or a shopping center for not having the right ramps or bathrooms, everything works out pretty easily, and they make the modifications. So there's different avenues for you to take if you want to effectuate change. You can self-advocate that way, or you can hire a lawyer like myself, and then at the end of the day, the property owner has to pay my legal fees. So not to be an infomercial about my services, but if anyone out there, is a wheelchair user or is deaf and has asked property owners to help them in the past, they know it's not always as easy as just asking nicely and getting a positive response. And in the time of COVID, of course, we're obviously very sensitive towards filing lawsuits against small businesses, especially restaurants and retail stores who are having a really tough go of it as is. So yeah, sometimes a request to a manager is the right way to go. Sometimes if they don't help, you got to file a lawsuit if it's a place that's really important to you or it's something that you feel is very important. But yeah, I can say that as someone who sues lots of restaurants and shopping centers for failure to provide ramps and bathrooms, we haven't been doing a lot of that lately because, well, first of all, our clients aren't going out to places, but we have to be very sensitive to balancing, that type of those types of lawsuits.
There was a comment on YouTube, our question, and would it be reasonable to expect legislative committee hearings or school board meetings to be live streamed via Zoom or other virtual platforms for those with disabilities to be able to participate?
I mean, the answer is yes. Like I said in my opening statements is, we filed a lawsuit on behalf of Harry Silver, a 98-year-old city councilman in Alexandria, who was not being allowed to attend city council meetings via Zoom, and we got a federal judge to agree with us and put forth an injunction, which is a way of a judge to say, hey, you got to do this. So, if you have a disability and you want to attend these meetings via Zoom, and it's because of your disability, they should enter into a dialogue with you about how to properly accommodate you, okay? Now, if you're not disabled and you're just don't want to get exposed to the coronavirus, I mean, I don't have any disabilities. I'm in no hurry to get into conference rooms with other folks. I think, common decency should win out. But with respect to the ADA and actually having a disability that would be affected by, if you have some sort of immune deficiency or things of that nature, that definitely makes you a person with a disability, and they cannot discriminate against you because of that disability. And having some sort of compromised immune system or compromised cardiovascular system or compromised respiratory will put you right in the basket, so to speak, of a person with disability. And then when you make the request, they have to engage with you, and if they don't, they're in violation of the law.
I just wanted to build on that answer. It was excellent. Just two things that I would add to it is the ADA speaks in terms of your right to participate in the benefits of any government program or service. And that includes decision making. So when the government holds public meetings, that is a program and service within the definition of the ADA. And you have a right to be a part of that because you are, a taxpayer just like everybody else. You should have a voice in how your government services are being provided. You also, I think, hit on a very good point that this is about a functional limitation, and something that's wrong with your immune system can be, sorry for the phone ringing in the background there. Your immune system can be a disability, and a disability isn't something that's defined outside of your day-to-day life. It's about your ability to function in the world. And so a lot of people who may never have thought of themselves as being disabled, just because they had, let's say, a minor case of asthma or a case of diabetes that didn't really interfere with their day-to-day life much at all, or require them to do, anything differently that would have ever made them ask for a reasonable accommodation. These things can suddenly now be risk factors that turn participation in even basic parts of day-to-day life into a disability, because your disability is based on your ability to function in context. So a lot of folks, I think, don't think of themselves as being a person with a disability, but nonetheless are having to navigate a post-COVID outbreak world where all of a sudden they're thinking in new terms. And one of the terms those people should be thinking in terms of is, am I a person with a disability because I can't fend off a COVID infection?
And so to follow up with in regards to open meetings, a couple of questions is if you're a caregiver of someone with a disability and be able to participate in meetings. So in regards to, oftentimes we have disability councils or different type of government groups that focus on disability. In order to have true, authentic stakeholder input, those people who are most affected by disabilities, including the caretaker, cannot travel, let's say from Shreveport or Monroe to a meeting in Baton Rouge in person. Would it be an appropriate ADA accommodation to allow a caretaker of someone with a disability to be able to participate in those meetings virtually?
I think I guess I'm a little confused by the question. Is if the caregiver has the disability?
No, the caregiver is a caregiver of a person with a disability, so therefore they cannot, due to the person's the person taken care of's disability, they can't travel or can't be away to be able to participate in that meeting. And so would that be an ADA accommodation, or does the law not go that far?
So the disabled person needs a caregiver, and the question is, can the caregiver give that care remotely?
No, can the caregiver request ADA accommodations to participate in a meeting virtually? Because they can't leave that person they're caring for that period of time to be able to travel to participate in that meeting in person.
So the caregiver is able-bodied,
right,
taking care of a disabled person, but can't leave the disabled person and wants to take part in.
Right. So usually it's parents of, parents who have kids that are have significant disabilities, and they can leave for that amount of time.
I gotcha. I don't know. That's a good question. I'd have to look into it. Do you know that, Jonathan or Cindy? That's it. I mean, I know that with respect to, deaf folks, if you're deaf and your child is hearing, you are entitled to a sign language interpreter to communicate with the doctors about your children. But I don't know. What do you think, Jonathan?
So, questions about when you, as a person with a disability, have a right to an interpreter. In general, these are very broad things. So if you are merely curious about something that is happening at a meeting in open court, like if you just are curious what's happening, you don't have to have any particular vested interest in it. If there's any particular open meeting where you're even just amateur hour curious, you should request an interpreter, and that interpreter, they have an obligation to provide you with an interpreter. For any basically, I'm trying to give advice that is as wide as possible without getting too deep into what I'm sure is somebody's very particular and individually motivated concern. In general, if you are having any kind of dealing with the government, whether that's parish, school, county, courthouse, landlord, tenant, anything, if you are dealing with the government, you should be able to request an interpreter and receive one. If you are dealing with any kind of private business, if you would like an interpreter to be there for something, generally, you should just ask for one and try to get them to set one up for you so that you can have the benefit of an interpreter while you are at a business. You may not always be able to get an interpreter, but even just asking and making sure that it's on the record triggers their obligation to provide you with a reasonable accommodation. I don't know how well that answered the question or if it built meaningfully on top of Mr. Bizer's answer, but I do think that it is always in your best interest, if you have any level of curiosity about anything or any level of desire to know more about what's happening at a meeting, or any will whatsoever to participate in the processes of government or decision making, even if it's something as small as a school meeting about a kid, or as big as a court case that you are just interested in. You should be able to request an interpreter in order to be able to participate in the workings of government.
And so, Jonathan, the question was the previous question was in regards to a caregiver, usually a parent of a child with a disability that wants to be able to participate in a open meeting, a public meeting. Would it be an ADA, would the ADA extend to the caregiver being able to ask for an accommodation to participate virtually in order to, because they can't leave their person, their child, adult child, whatever it is, alone to be able to attend that meeting?
Okay, so in a situation where you have an adult child and there's a request for a reasonable accommodation because you're trying to care for somebody, you may not yourself have a right to a reasonable accommodation because the right to a reasonable accommodation under the ADA follows an individual's disability. But I do think there is now a giant untested area of law here where if you have a person with a disability, a lot of times for almost all disabilities, that's gonna fall within the COVID risk group, except for things like mental illness. And I think there may be a very good argument that this person has the right to a reasonable accommodation because of the risk that they could pose to the person they're taking care of. So I'm not actually certain, but I think that lack of certainty comes from the lack of case law.
Right. Thank you.
Okay, we actually have some questions in the chat box. So since we were talking about like caregivers, basically parents with children with disabilities, Ms. Kathy Dwyer had a question. What about during COVID? Caregivers can't risk exposure for fear their child might be exposed. Would ADA apply in terms of live streaming?
I think that's really closely related to the last question, that it's in some ways almost the same analysis, where the ADA at law creates rights for people with disabilities or people who are regarded as having disabilities. Now, we've never tested, and at least I'm not aware of a situation where we've tested a situation where somebody says, I am a person with a disability. I fit under the ADA. I have a caregiver, and that person would like to attend a meeting. In order for me to manage my risk, because this is a contagion, that person must also manage their risk. My care worker must also manage their risk in order to accommodate me as a person with a disability. Therefore, I would like for my care worker to be able to participate in that meeting remotely. That analysis really just hasn't come up too much inside of the ADA because in the past, there were times when people were, of course, immunocompromised, and people did have to take steps around preventing exposure by themselves to pathogens, but the idea that there's now an ambient risk that's posed by any large gathering of people, pretty much anywhere, and that risk is now mortal. Like we said earlier, it changes the context, and the question of what is a disability is driven by your ability to function in context.
Yeah, and just to follow up to Jonathan, I think the answer is we don't know. And sometimes the law, we don't know, because we're, lawyers don't have all the answers. Congress, when they drafted the ADA, thought about a bunch of stuff, had debates on it. Some of that stuff ended up in the law, some of it didn't. When they updated the law in 2010, sometimes they updated with certain stuff that was important. Sometimes other stuff didn't get in. So, I wish I could say, yes, you have that right, it's protected. Or I wish I could say, no, that's not there because this happened and we found out. Sometimes the law is ambiguous. I would argue that the answer is no, but it depends but I'm thinking as a lawyer where you got to file a lawsuit and then they're going to file something that says the ADA, it's not in the plain text of the ADA and therefore we can't read into it. And then a judge has to decide it and it takes months. And so who knows? Not a good answer, but that's the answer.
Well, thank you so much. We actually have a few questions regarding like open meetings, because this whole topic of like live streaming and being able to participate in meetings during the pandemic has become a really popular topic. So another question in the chat box is, regarding open meeting laws in Louisiana, the laws that require in-person participation have been relaxed due to the overwhelming concerns of COVID. We have seen technologies like Zoom enable attendees of a given meeting to fully participate. Assuming that the laws requiring in-person participation be reinstated, if a request to participate in a meeting remotely is denied under state law, is this a violation of the ADA, given the technologies like Zoom enabling reasonable access for individuals with disabilities to participate in public meetings?
Yeah, I would just say it's similar to the Alexandria case that I talked about. So if the person has a disability and they want to attend this meeting via Zoom, then I would argue that they have the right to do so because of their disability. If Andrew Bizer, a person without a disability, wants to attend a meeting via Zoom, let's say there's a New Orleans City Council meeting that they don't have it set up for Zoom or what have you, I don't have a right to sue. I'm not a person with a disability. I don't have a compromised anything that I'm aware of, at least. So no, not through the ADA would you have a cause of action. But if you have a disability and you feel like your disability would be impacted, whether it would be exacerbated or whether it would open you up to COVID or any other type of disease, then yeah, you definitely have a right to ask for a reasonable accommodation, and they should grant it. And if they don't, unfortunately, that's what the courts are for, to enforce the law and make local municipalities comply with federal civil rights law. But if you don't have a disability, you can't take advantage of the Americans with Disabilities Act. It's that simple.
So I agree with everything he just said, that having a disability is, really the first step to the ADA applying, and any application of the ADA for a person who does not have a disability is going to be a real reach. And it's going to depend on people treating you like you're a person with a disability. And that's going to be complicated territory that you're going to have to call an attorney about. But I think one thing this question is kind of hinting at is something that we haven't really talked about yet. We talked about the way a definition of a person with a disability changes during the pandemic, and that people who hadn't previously considered themselves disabled may now fall under this definition. But that's not the only part of our context that's changing. There's new context of improving technology and remote connection, which didn't used to, like if you'd said you wanted to participate in a meeting remotely in 2002, you probably would have gotten laughed at for most applications of the Americans with Disabilities Act. But now that the technology is widely available and a standard feature on almost every laptop, the question of what's reasonable to request as an accommodation has been changing a lot and quickly. And reasonableness is based on, you know, the severity of the risk to you, the cost of implementing a solution. If it's as easy as setting up a laptop so you can just speak through a laptop at a meeting, it's going to be real hard for a city council or other open meeting to shut you down and say no. But again, like we were saying, unless you, a person with a disability, are bringing a lawsuit about your own rights as a person with a disability, it's not really going to fall under the ADA. And I think because of the amount of popular concern about this and the number of people who are sort of suddenly afraid, not for themselves and their rights, but for the way that they're going to impact their families and loved ones, it may be the case that it makes more sense to try to pass new laws and to move the needle forward in terms of what counts as a civil right. How do we treat people with disabilities in this society, and what is fair? Those things might be best addressed through new legislation, saying things like open meetings should now have a Zoom component where anybody who's from the impacted community in Louisiana should be able to, at a minimum, join and hear by Zoom and be able to submit questions. That seems like a reasonable accommodation to me, but in order to expand it from the current thinking of reasonable accommodations only apply to people with disabilities to this new idea that we need to protect people with disabilities by containing social interactions, that might simply require new law, or at least big reinterpretations of the ADA in big test cases. And whenever you do big new cases and big tests, you get uneven results. Some circuits will probably say, yeah, you have a right to a reasonable accommodation to protect your family member with a disability, or your family member with a disability has a right to protect themselves by you participating remotely in something. That could be how things shake out in the Ninth Circuit. I doubt as a practical matter that it would be how things shake out in the Fifth Circuit where we live, which tends to be very conservative and focused strictly on the language of the statute. So when progress is uneven like that, that's when it calls for new federal laws and new decision making.
And Jonathan, just one last thing in regards to that, what you said, new laws to be made or to be enacted. We are looking at the very issue, even prior to COVID, as I made the case about caregivers wanting to participate and be a voice at these meetings, looking at changing state laws to allow that participation. So I think that might be, I'm not an attorney, but I think that might be an avenue to be able to change in Louisiana. I think COVID actually will be able to help move that forward, because we see that we can do it. And so hopefully we can get some legislation done while Governor Edwards is still in office, so very soon. Okay, Kiara, if you want to go into another topic. I know we talked about open meetings quite a bit, but there's some other topics I know.
Yeah, sure. So Sharon asked a question regarding caregivers of adults with intellectual disabilities not being able to speak or make medical decisions for themselves. If they're hospitalized during this COVID period, do they have the right to have a caregiver with them who is legally allowed to make decisions for them?
So this is kind of a complicated question because it's phrased in terms of, do you have a right to have a caregiver with you? And physical presence inside of a hospital, especially one responding to an emergency or where the risk of contagion is extremely high, you probably do not have the same right to have a care worker or friend in the room with you that you might have had under different circumstances. So one of the ways that the pandemic can shape what's reasonable under the circumstances is by changing what is and is not dangerous behavior. And one of the things that is very important in a hospital setting is maintaining control over the risk of contamination. And if you simply have someone who is in a sick room with somebody who you know to be infected, that person who is infected is generally not able to leave their room, sometimes not even able to leave their bed. But having a person who is in there with them, who is traveling into and out of that room multiple times per day, touching objects, leaving to get food and interacting with other people, that can be the kind of thing where somebody is could reasonably apprehend that there is some danger. So if you need to be physically present, it's going to be important that you speak with the hospital in advance. And if you're concerned that they're not adequately accommodating your need to be with somebody about whom you're making decisions, then it would be a good time to talk to Mr. Bizer or myself about what your rights are under those circumstances. But as far as like the blanket question of, do I have a right to have someone in the room with me if you're suffering from COVID or in a hospital environment during the COVID emergency? The answer to that might be different than it used to be, and it might be a lot more delicate than it used to be.
I had a case recently that it just settled, which was kind of a bummer for me because it was sort of a meaty legal question that I would like to sort of find answers to. Like I said before, sometimes the answers don't exist until a judge rules on his or her interpretation of the law. So I had a deaf woman who had an emergency C-section. She had a sign language interpreter right at her side, and the doctor said, look, we're going into an operating room. You can only have one person in the operating room with you. You can choose the sign language interpreter, or you can choose the father of your child. What's it going to be? Which is a horrible thing to do, right? And, this is pre-COVID. So, she chose the father of her child to join her in the operating room, and had a very stressful birth of her child because she couldn't communicate. The father of her child was only a finger speller. So it was just a nightmare. So we filed suit and they eventually settled the case. But, I was looking forward to that fight because, the hospital's position is, look, we're in charge of the operating room and making sure that there's less breathing bodies spewing out possibly infectious, stuff. And my argument would have been, one more person wouldn't have hurt you. You could have gotten a bigger operating room. There's PPP that they could have worn, the whole thing. But again, this is another example of this. Sometimes there aren't really good answers. And that, I can tell you that juries and judges want to give as much deference to medical providers as possible, especially now. So yeah, that's a tough fight. If you're a caregiver to a person with disabilities, mental disabilities or otherwise, it gets you in the room. It's uncharted territory. There's no real good answers to any of this stuff. So.
In that case that you just spoke about, were there no options for like having the interpreter on a screen, like on an iPad or something, to be
Great
able
question. Yeah, no, they didn't offer a VRI. VRI, for those of you who don't know, is just like a laptop or an iPad where you can sort of Zoom with the interpreter. So that was sort of our safety net, so to speak, in that case, was that if they felt like they could defeat us on the argument of another person, our safety net was, yeah, but you didn't even offer her the VRI. So for a yes, for a deaf person, having a VRI would have been more helpful than nothing. But you know, when you're giving birth, you would like to have a live person there because the cameras and the operations, nobody wants to be having all of that over the internet to some other person. But the point being, yes, they could have offered the VRI and they did not. And I guess similarly, if a caregiver wanted to be FaceTiming with the doctor, that would be a reasonable accommodation request. If you say, I have a mental disability and I need someone to help on my behalf, that's the whole thing I was talking about at the beginning, right? Is they have this affirmative duty to accommodate, and they have an affirmative duty to just get into a dialogue with you. And if they say, well, yeah, but we got this, you know, you could Skype with the doctor and that way you're not in the room and no one's getting hurt. And then you say, well, you know, that's not terrible. That's not ideal, but COVID's not ideal, right? And we all got to figure out a way to handle it. So.
Yeah, well, one of the things that I just wanted to piggyback off of, because it was a really great point, is sometimes the only thing that can defeat a request for one reasonable accommodation is a different reasonable accommodation. And the way the question teed it up as, do I have the right to be in the room? Now, the answer to do I have the right to be in the room might be no, if they can set up a situation where you can have telepresence. And there's going to be a lot of different questions about, is that adequate under the circumstances? And for things like childbirth or last goodbyes, there can be an emotional weight to the moment that requires or is maybe best served by physical presence in the room that wouldn't be the same if it were through a laptop or through VRI or you know, just over the phone. And so there's going to be a lot of questions about when can you do telepresence, when can you be in the room, but in general, you have the right to, if you've given somebody your durable medical power of attorney and you're out, you do have the ability, or you should have the ability at least to talk with that person and to help that person make decisions about you, to make sure that your wishes are clearly understood and that your consent to any medical procedure is authentic. But adding on to that, other questions about the emotional weight of particular moments that may be unfolding in a hospital is also going to have an impact on this analysis. And there can be a complicated relationship between your idea of what a good reasonable accommodation is and what a hospital's idea of a good reasonable accommodation is. And I see a lot of tendency and push for the hospital to treat the maximum risk-averse thing as the only my way or the highway reasonable accommodation sometimes. So if you have a question about what's going on with you know, whether you should be allowed to be physically present somewhere, I think you're in good company, and those questions are very sensitive to the facts, and you might want to talk to an attorney about them if you feel very, very strongly. And that would be Mr. Bizer in my office.
Thank y'all so much. We have about 6 more minutes. This question was posed, and I think it's a really good one. And it's also something that I've been researching this summer as I've been working with the governor's office. So most individuals who raise concerns cannot afford attorneys to file challenges or complaints under the ADA. Do you know how states, local entities can establish departments to enforce or help with compliance of the provisions of the ADA that do not require the adjudication of the courts?
Sure.
You first.
Yeah, sure. First of all, just so you know, I know that we don't charge anyone a fee out of pocket. If we're successful, we get paid by the property owner that is doing the discrimination. And if we lose, then we lose and we don't charge the client. We just sort of eat it because we think that we do a good job of screening our cases and we only take the winners. And I know that Jonathan's, he can speak for his group about how, you know, they assist folks for free. But, you know, it's tough. It is. If it's a strictly, there ain't no ramp at this restaurant, I assume they can reach out to Cindy, correct, Cindy? Is that right? Right. Or they can contact the Department of Justice. You know, we can, you know, make whatever assumptions we want to make about the Department of Justice's current priorities and whether they really want to help disabled folks these days. But those are two avenues that you can take, reaching out to the Department of Justice, reaching out to Cindy, or just reaching out to you know, the Advocacy Center, or any other types of centers that do advocacy for the disabled.
So,
Go ahead.
yeah, Disability Rights Louisiana, which used to be called the Advocacy Center, now Disability Rights Louisiana.
Sorry about that.
No worries at all. I still trip myself up with it almost constantly. We are federally funded. So we are your tax dollars at work. And we represent clients on very similar terms. We never charge a client a penny for any of the work that we do. We take cases that are civil rights cases, and so they qualify for attorney's fees under the civil rights statute. So we're, you know, we're basically on the same model there. Because we receive federal money, can sometimes take cases that are more on principle or less certain, that relate to the rights of people with disabilities, because we are subsidized by the government and granted with certain federal powers that come with that. Now, the question also asked kind of a subpart of, I'm a person with a disability, I don't have the resources to challenge something, and maybe his office and my office don't agree to represent or don't have the resources to represent, because, you know, our office does work statewide, and we have to, even with federal funding, we have to pick our battles very carefully because we have very few attorneys relative to the number of problems in the state. Now, one thing that the city of New Orleans recently did was they started a Human Rights Commission for the city of New Orleans that hears complaints and does an investigation and adjudication of them. I understand they have a filing fee. I haven't personally worked through their process yet. And my understanding is that it is geared towards people who are not attorneys. Now, if you don't live in New Orleans, one thing that you might consider is whether or not that legislation is a good model for something that you would like your city and your community to consider on their own. I will say that also, you don't need necessarily to be an attorney to get results. Sometimes, especially with city governments or local governmental agencies or entities like a school board, a lot of times those governmental officials are sensitive to things like political pressure or articles appearing in the newspaper, or even just, you know, tough questions being asked of them at campaign events. And so there are ways of, especially where something is not a business but is a public entity, that's where your voice is at its strongest, and your ability to use media to push the government or use questions to push the government, where that can really start to matter. Also, sometimes just going to social media and making clear what happened to you and, you know, what you think needs to be done to make things right. Because I think you're correct that not everything can be a lawsuit. That, you know, there just aren't enough attorneys practicing in this area to turn every violation of a person's rights into a successful lawsuit. So sometimes you do have to use those other tools, but we do, my office will always encourage you to try to talk with an attorney first before you start making a bunch of public statements on social media. Because if you are familiar with any of the police shows, it's not just police shows. Anything you say can and will be used against you in a court of law for pretty much anything. So if you make a public statement cussing somebody out or giving a version of things that doesn't turn out to be quite accurate, that can really complicate a legal case later. So if it's something where you think you might want to bring a legal case, it's probably best to talk with the lawyer before you take those public avenues that we were just talking about. I saw Cindy raising her hand.
Very briefly, I'd like to add to that, what we typically advise people to do is first to go to the owner or the tenant with your issue. Secondly, call the Office of State Fire Marshal and let us know what the problem is. If it was a problem that existed prior to 1995, we're going to give you information about how to contact the Department of Justice. And the last thing that I might suggest is for you to call your congressman. We receive phone calls from the senators, congressmen weekly that have to do with a constituent's issues with accessibility. And we do look into them. A phone call is returned, an email is sent. Most of the time, an inspector is sent out to cite a violation and a plan of correction is required.
Alrighty, thank y'all so much. Each of you have provided such great information, especially for me, just because I'm going into this area upon graduating from law school. But again, thank you all so much. Bambi, do you have any final words?
Yes, I just want to thank you guys again, and Andy and Jonathan and Cindy, for giving us such great information. We appreciate it. Thanks to everybody who has participated today. It was a great session, our first virtual conference. A lot of participation. I think things went really well, went pretty smooth, a few hitches. We'll start again tomorrow morning at 8:30. Our first session is at 8:30 with higher education. We're going to have people speaking about supported decision-making, which is a new law that's passed in Louisiana, vocational rehabilitation services, housing, transportation, and voting. So tomorrow's going to be jam-packed with information. We'll follow the same process with Zoom and YouTube, and appreciate everyone's help and participation. So y'all have a good evening, and see y'all back here tomorrow. Thanks, guys.
Thank you.
Thanks, Sylvia and Landon.